To make these wearables work, or to state more clearly, to be able to obtain useful information from the data collected, we need applications. When we use a wearable, for example, a smartwatch, to track our exercise and health during our workout, we are constantly transferring our data to the application associated to this wearable. At the same time, of course, these data are stored in a server somewhere. Therefore, it is important to understand that the close interaction between applications and the operating system of smartphones and tablets enables application for mobile devices to access a number of data significantly higher than those accessed by a traditional internet browser. Furthermore, during this process, we must ask ourselves, which data are being collected, where are they being stored, for what purpose are they being processed, and finally, who has access to all my personal data? Having thought about the answers to all these questions, we can realize that there are risks we must be aware of. In the development of a mobile application, user rights are not frequently considered a high priority. Potential violations of these rights are many: lack of transparency, lack of free and informed consent, poor security measures, or infringement of the principle of purpose limitation. Going back to the questions we had asked ourselves before, clarifying who is going to have access to our data is also an important part in the prevention of the misuse of personal data. We must take into consideration that during the processing of personal data by mobile applications, many different parties may step in. As you can see, these parties may be application developers, which include the owners of these applications, also the manufacturers of the operating systems and devices, such as smartphones and tablets, also the application stores which distribute the applications, and also other parties involved in the data processing, which are usually processing the data for commercial purposes. So, for example, here we have an image of what we are talking about. We can see a smart bracelet that has been manufactured by a company, and to make it work, they for sure use a software that may be developed by another company. And there is also the smartphone, and we can see the application by which we can connect the device, the mobile device, with the bracelet. So here, all this data, the flow of this data, we can see it in the image. Talking about this, we have an example of a problem that has occurred between an application and a wearable. This was, it's a Dutch DPA case, and it was about Nike Plus application. This was an application for fitness, especially for runners. And the relation was between the application and intelligent sport shoes. And this was the relation. The thing was that they found that that application and the flow of the data was violating the data protection laws. Because in that case, the thing was that Nike developed this application. This was, as I said, especially for runners, which they could track their activities. So the application enabled to track the distance, the speed, the time, and the calories burned. So users could improve their performance with personal training programs and compare their performance with other users. So the Dutch DPA found in this relation, in this data transfer, at least three violations of the data protection law. The first one was that it did not provide enough information on what personal data was processed and for which purposes. And it didn't mention that the data were stored indefinitely. The second thing was that the application processed health data and had not obtained the required explicit consent of the users for this processing. And the third one was that they found that there wasn't a legal basis to process and use other informations collected also by this application, such as location information and contact information of the users.